Hey everyone, this is Mac. I'm a trainer here at US Realty Training. And today we're going to go over 25 of the questions that are going to be on your Texas real estate exam. If you are interested in more questions and information and tools to prepare for your state exam, feel free to click on the link below in the description box or in the comments. And with that said, let's start with the first question. Lewis owned a boat and a house before marrying Barbara. While she was single, Barbara owned a new car. The two got married and bought a second home. As a wedding present, Barbara's father bought Lewis a motorcycle. Under the law of community property, what property can Lewis sell without his wife's consent or signature? A, the boat and house. B, the boat, house, and motorcycle. C, the second home and the motorcycle. D, the boat and motorcycle. And the answer is B as in boy, the boat, house, and motorcycle. Separate property consists of property owned by either spouse at the time of the marriage, property acquired by either spouse through inheritance or gift during the marriage, property acquired with separate property funds, and income with separate property. Community property consists of all other property earned or acquired by either party during the marriage. A spouse owns separate property free and clear of claims by the other spouse. He or she can transfer it without the other spouse's signature. Upon the death of a separate property owner, the property passes to heirs by will or laws of descent. Community property cannot be transferred or encumbered without the signature of both spouses. Upon the death of either spouse, half of the deceased community property passes to the surviving spouse, and the other half passes to their decedent's heirs. The bundle of rights refers to a set of rights. A, enjoyed by the owner of a property. B, that is synonymous with the Bill of Rights. C, guaranteed by citizens by the Statute of Rights. D, specified in a deed or land contract. And the answer is A as in apple, enjoyed by the owner of a property. This group of rights includes the right to possess, use, transfer, encumber, and exclude others from using the property. Remember P-U-T-E-E, Pooty. Transfer rights include the right to sell, rent, donate, assign, or bequeath. The owner may also encumber the item by mortgaging it as collateral for debt. The right to encumber a property means that the owner can A, sell the property to an encumbered party. B, pledge the property as collateral for debt. C, lease the property. D, assign the bundle of rights to another. And the answer is B as in boy, pledge the property as collateral for debt. The right to encumber the property essentially means the right to mortgage the property as collateral for debt. There may be restrictions to this right, such as spouse's right to limit the degree in which a homestead may be mortgaged. So just remember the definition of encumber is to use the property as collateral for the loan. An item may be considered personal property as opposed to real property provided that A, the owner intended to remove it after a period of time. B, it can be removed without altering the appearance of the structure. C, it is unnecessary to the physical integrity of the structure. D, the owner installed it at some time after acquiring the real property. And the answer is A as in apple. The owner intended to remove it after a period of time. One's original intention can override the test of movability and determine whether an item is a fixture or not. If someone attached an item to real property yet intended to remove it after a period of time, the article may be deemed personal property. If a person intended an article to be a fixture, even though the item is easily removable, the article may be deemed a fixture. For example, an apartment renter installs an alarm system, fully intending to remove the system upon lease expiration. Here, the alarm system would be considered personal property. So what this is referring to is essentially who owns the item and what was the purpose in installing that item in the unit or the property. So if a tenant installs the item, then more than likely the tenant, when they move out, will take that item with them. Therefore, that item would be considered personal property. But let's say a landlord installs a chandelier in the bedroom. Well, the landlord's intention is to keep that item in the bedroom irrespective of who is living in the apartment. Therefore, that chandelier would then become a fixture. Also remember, what is a fixture? A fixture is an item that was once personal property, i.e. a chandelier in a box, right, in a shipping crate, versus that chandelier being installed into the apartment building, which then makes that chandelier a part of the real property. A tenant in common can A. Sell or transfer his interest without the consent of the other tenants in common. B. Use his or her interest in the estate to encumber the entire estate. C. Sell, encumber, or transfer his or her interest only to other tenants in common. D. Sell, encumber, or transfer his or her interest only with the consent of all the other tenants in common. And the answer is A as in apple. Sell or transfer his interest without the consent of the other tenants in common. All tenants in common have district and separable ownership of their respective interests. Co-tenants may sell, encumber, or transfer their interests without obstruction or consent from the other owners. A co-tenant may not, however, encumber the entire property. So essentially what this is saying is that in a tenant in common situation, let's say property owner A owns 75%, property owner B owns 25%. Property owner B does not have to get permission from property owner A to sell his or her rights, to sell, to transfer, to gift their rights. However, the property owner B cannot mortgage the entire property. They can only mortgage 25% of the property, or the amount that they have an interest share in. Littoral rights apply to which of the following? A. Boatable ponds entirely contained within the boundaries of an owner's property. B. Streams and rivers. C. Navigable lakes, seas, and oceans. D. Navigable streams and rivers. And the answer is C as in Charlie, navigable lakes, seas, and oceans. Littoral rights concern properties abutting bodies of water that are not moving, such as lakes and seas. Owners of properties abutting a navigable, non-moving body of water enjoy the littoral right of use, but do not own the water nor the land beneath the water. The legal premise underlining the definition of littoral rights is that a lake or sea is navigable body of water, therefore public property owned by the state. By contrast, a body of water entirely contained within the boundaries of an owner's property is not navigable. In such case, the owner would own the water as well as restricted rights of usage. What is the function of recording a deed? A. It makes the deed valid. B, it causes title to pass. C, it gives constructive notice of ownership. D, it removes all prior recorded encumbrances. And the answer is C as in Charlie. It gives constructive notice of ownership. Recording is not necessary to make a deed valid. However, it is in the grantee's best interest to do so. Recording the deed gives the public constructive notice of the grantee's ownership. So, essentially, recording, what is it? It's when the county acknowledges the transfer, stamps the deed itself, and now that deed is public record. So now the county is acknowledging the new buyers of the property. Is it required? No. Is it useful to the new homeowners? Absolutely. Mr. King wants to offer 100 acres to his property for sale. Since the property is landlocked, he will have to put in a driveway to the road that will run across the remaining property. What kind of easement will he have to grant? A, an easement in gross. B, a commercial easement. C, personal easement. D, easement appurtenant. And the answer is D as in dog, an easement appurtenant. An easement appurtenant gives a property owner a right of usage to portion of an adjoining property owned by another property. The property enjoying the usage is called the dominant tenement and dominant estate. The property containing the physical easement itself is the servient tenement, since it must serve the easement use. So just remember a couple of things. The word appurtenant means to go with the land or to come with the land. So if there is an existing agreement, an existing easement on the property, whoever the owner is inherits that easement or the right to use that property. Now, remember also, with regards to an easement, there's a dominant tenement and a servient tenement. The servient tenement is the one that gives up their land, in this case for that road that Mr. King is going to need. The dominant tenement is the one that benefits from the usage of that land. Melinda purchases a house and finances it. The lender in turn places a lien on Melinda's title. The lien in this mortgage transaction is A, evidence of debt incurred by a property owner. B, a promissory note granted by a property owner as security for a debt. C, the creditor's claim against the property as collateral security for the loan. And D, the document required to clear clouded title. And the answer is C as in Charlie, the creditor's claim against the property as collateral security for the loan. A lien is a creditor's claim against personal or real property as security for a debt of the property owner. If the owner defaults, the lien gives the creditor the right to force the sale of the property to satisfy the debt. For example, a homeowner borrows $5,000 to pay for a new roof. The lender funds the loan in exchange for the borrower's promissory note to repay the loan. At the same time, the lender places a lien on the property for $5,000 as security for the debt. If the borrower defaults, the lien allows the lender to force the sale of the house to satisfy the debt. Essentially, what this is saying is that the borrower is putting their property up as collateral for this loan. And in this case, it'd be $5,000. This, in its sense, is what we would call to encumber a piece of property.
Hey everyone, sorry to interrupt. My name is Robert Rico and I'm the head instructor here at US Realty Training. If you're enjoying these questions, I want to remind you that you can get hundreds of similar questions just like these. In fact, get it today. Hey, you know what? While I'm at it, while I'm here, why don't I just do these next couple? Let's get straight to it. Okay, so George Scott hires Shannon Lang to sell his house. So in this case, George Scott is the owner. Shannon Lang is going to be the real estate agent. Here we go. George Scott hires Shannon Lang to sell his house with the condition that he will not be the first one in the neighborhood to sell to the members of a certain ethnic group. What should Shannon, the real estate agent, do about this condition? Now think about this. The owner of this house is telling Shannon, the real estate agent, he refuses to sell his house to a certain ethnic group. Whoa. Here are the answers. A, inform Scott that the condition is illegal and that she cannot comply with it. B, note the condition on the listing agreement and have Scott initial it. C, pretend that she did not hear the condition and proceed to market the property to all groups. And last but not least, D, tell Scott that she will try to discourage members of that group from looking at the property, but that she cannot control cooperating brokers. Now, what is the answer? All right, I want you to think of this logically. The answer to that is A, inform Scott that the condition is illegal and that she cannot comply with it. We don't want to take part in any of that kind of stuff. That's discrimination. Scott is not allowed to discriminate based on race, color, religion, national origin, sex, family, status, or handicap. If an agent goes along with the client's discriminatory act, which you already know is no bueno, it's not good, the agent is equally liable for a violation of fair housing laws. It is thus imperative to avoid complicity with client discrimination. Furthermore, an agent should withdraw from any relationship where client discrimination occurs. A homeowner resides in a new subdivision managed by a homeowners association. What obligation, if any, does this fact create whenever the owner decides to sell? Interesting question. Owner owns the property. There's a homeowners association involved with this property. What must be done when he's ready to sell? Let's go straight to the answers. A, the owner must advise any buyer of the managing entity and associated fees prior to closing. Answer B, the owner must advise the buyer of all homeowner obligations or face a 30-day exposure to contract rescission. Answer C, the licensee must disclose the association's existence or face disciplinary action. Or last but not least, answer D, the owner must disclose the existence of the association and all obligations accompanying membership. What is the answer? Think of this. You got it? The right answer is D. The owner must disclose the existence of the association and all obligations that accompany the membership. Now let's go straight to the explanation. The property disclosures include fee payments, default consequences, and all usage covenants and conditions. Failure to disclose prior, this is the key one here, prior to execution of the purchase agreement creates a 7-day rescission window. Thanks for letting me drop in, everyone. I'll kick it back to Mac.
A buyer submits an offer to a seller and then dies in a car accident. Before learning of the buyer's death, the seller accepts the offer. Which of the following is true? A, the seller can force the buyer's estate to go through with the purchase. B, the buyer's death terminated the offer. C, the seller must make a new offer with the same terms in the buyer's heirs. D, the buyer's heirs have the option of forcing the contract. And the answer is B as in boy. The buyer's death terminated the offer. Any of the following actions or circumstances can terminate an offer: acceptance, rejection, revocation, lapse of time, counter offer, or death or insanity of either party. Which of the following is an executory contract? A, an expired lease. B, a sale contract before closing. C, a recorded sale contract. D, an option to buy after it is exercised. And the answer is B as in boy. A sale contract before closing. An executory contract is one in which performance is yet to be completed. A sales contract prior to closing is executory. While the parties have agreed to buy or sell the buyer has yet to pay the seller and the seller has yet to deed the property to the buyer. So remember again, executory means that a performance has not yet been completed. An executed contract or performance means that the contract has been signed by both parties and or the conditions have been performed. A bilateral contract is one in which A, both parties promise to do something in exchange for the other party's performance. B, both parties receive equal consideration. C, two parties agree to perform a service together. D, both parties promise to do something if the other party performs first. And the answer is A as in apple. Both parties promise to do something in exchange for the other party's performance. A bilateral contract is one in which both parties promise to perform their respective parts of an agreement in exchange for performance by the other party. An example of a bilateral contract is an exclusive listing. The broker promises to exercise both diligence in the efforts to sell the property, and the seller promises to compensate the broker when and if the property sells. So remember what a bilateral contract is. A bilateral contract is when both parties listed on the agreement signs it and agrees to the conditions, right? This again, remember, bilateral meaning both parties. If the contrast to bilateral will be unilateral, meaning one-sided, right? So think of going to the gym. When you're doing a bilateral bicep curl, you're using both arms to do a bicep curl. A unilateral bicep curl would mean you're just maybe doing one arm, like your right arm, and a bicep curl. A breach of contract is A, a termination of the contract by the mutual consent of the parties. B, financial damage suffered by a party because another party has nullified a contract provision. C, a lawsuit to force a party to discharge the contract. D, the failure of a party to perform according to the terms of the contract. And the answer is D as in dog. The failure of a party to perform according to the terms of the contract. A breach of contract is a failure to perform according to the terms of the agreement. So, examples of breach of contract could be something to the effect of a buyer is mandated or is agreed to perform their investigations a certain period of time and so forth. If the buyer does not perform in that specified time, then that buyer is in breach of contract. Another example of breach of contract is when the escrow does not close in time. And either buyer or seller, whoever's causing the delay, is in breach of contract. Agent Michael is showing his new listing to a buyer who informs him that he has just inherited $5 million. Michael is now bound by fiduciary duty to A, keep the information in confidence, B, disclose the information to the buyer's agent, C, disclose the information to the seller, D, verify the buyer's statements before disclosing them to the client. And the answer is C as in Charlie, disclose the information to the seller. An agent has the duty to inform the client of all material facts, reports, and rumors that might affect the client's interest in the property transaction. This includes the agent's opinion of the property's condition, information about the buyer's motivations and financial qualifications, discussions between agent and buyer regarding the possibility of the agents representing the buyer in another transaction. Commingling is the practice of blending escrow funds on a number of properties in one escrow account. B, mixing socially with prospects at open houses or other marketing functions. C, allocating commission funds with a transaction for use in the agency's business. D, mixing escrow funds with the broker's operating funds. And the answer is D as in dog, mixing escrow funds with the broker's operating funds. Commingling, a prohibited activity, is the act of mixing the broker's personal and business funds with escrow funds. So remember, most brokerages will have two bank accounts. One would be considered a trust account or escrow funds account, and the other would be their operational account. A broker cannot commingle funds, meaning this, they cannot be paying their operational expenses from that escrow fund account or that trust account, right? So both accounts have segregated responsibilities and operations. On Wednesday, Fred offers to sell his property to Jack for $275,000 with the offer to remain open until 5 p.m. the next day. On Thursday morning, Sally offers Fred $280,000 for the property and Fred accepts. At 1 p.m. on Thursday afternoon, Jack accepts. Which of the following is true of this situation? A, the acceptance by Sally creates a contract and terminates Fred's offer to Jack. B, Fred has entered into contracts with both Jack and Sally to sell the same property. C, Fred's acceptance of Sally's offer is invalidated by Jack's acceptance because Fred's offer to Jack was made prior to Sally's offer to Fred. D, no contract has been created because it is impossible to have two valid sale contracts for the same property. And the answer is B as in boy. Fred has entered into contracts with both Jack and Sally to sell the same property. Jack's acceptance of Fred's offer creates a valid contract. Just as Fred's acceptance of Sally's offer creates a valid contract. Fred should have revoked his offer to Jack before accepting Sally's offer. Several buyers are competing for the last available home in a desirable new subdivision. One buyer calls the owner-developer directly on the phone and offers $20,000 over and above the listed price. The developer accepts the offer. At this point, A, the parties have a valid enforceable sales contract on the home. B, the parties have completed a verbal executory contract. C, the parties may not cancel their contract. D, the developer could not entertain other offers on the property. And the answer is B as in boy. The parties have completed a verbal executory contract. As a sales contract created by an offer and acceptance, the parties have an executory contract. The parties have yet to perform their respective obligations and promises. However, as a contract for the sale of real estate, this verbal contract is not enforceable. An enforceable real estate contract must be in writing. So remember the difference between executed and executory. Executed means both parties have signed contracts, which means the terms of those contracts are enforceable. An executory contract means that both parties are about to sign the contracts. They have not signed them yet. Therefore, that executory contract is not enforceable. New federal regulation in advertising requires email advertisers to give recipients an option to discontinue receiving emails from such advertiser. This legislation is called A, the CAN-SPAM Act, the CAN-SPAM Act. B, the Truth in Advertising Act. C, the Telephone Consumer Protection Act. D, the Email Advertising Prohibition Act, or EAPA. And the answer is A as in apple, the CAN-SPAM Act. The CAN-SPAM Act bans unwanted commercial messages sent to wireless devices, requires prior authorization to transmit certain messages, and requires an opt-out provision where the receiver can shut off the advertiser from sending future messages. Okapi Inc., a company that markets its sports clothing worldwide, moves into Stevensville and hires 100 employees. It is reasonable to expect that the town will experience A, an immediate rise in the demand for industrial real estate, but no other changes in the real estate market. B, an increase in demand for all types of real estate. C, a housing boom, but no other changes in the real estate market. And D, an immediate increase in the prices of industrial and office real estate, but no impact on the residential market. And the answer is B as in boy, an increase in demand for all types of real estate. New businesses will arise to support the new company. They will hire new employees, some from out of town. The new employees will need housing, hence the demand for residential real estate as well as commercial and industrial will intensify, as it will also stimulate new construction. What is a loan-to-value ratio? The percentage of a lender's portfolio that is composed of mortgage loans. The ratio of borrowed principal plus total interest to the appraised value of the collateral property. C, the ratio of lender's return on a mortgage loan to the value of collateral property. D, the fraction of the appraised value of the property offered as collateral, which the lender is willing to lend. And the answer is D as in dog, the fraction of the appraised value of the property offered as collateral, which the lender is willing to lend. The relationship of the loan amount to the property value expressed as a percentage is called the loan-to-value ratio, or LTV. If the lender's loan-to-value ratio is 80%, the lender will lend only $80,000 on the home appraised at $100,000. The difference between what the lender will lend and what the borrower must pay for the property is the amount the borrower must provide in cash as a down payment. AMC Bank discovers in considering buyer Bob's application for a mortgage loan that Bob has borrowed the down payment from an uncle and has to repay the loan. Bob should expect that AMC Bank will A, refuse the application, B, adjust the applicant's debt ratio calculation and lower the loan amount, C, increase the loan amount to enable the borrower to pay off the loan to the relative, D, require the borrower to make payments to an escrow account for repayment of the relative's loan. And the answer is B as in boy. Adjust the applicant's debt ratio calculation and lower the loan amount. Since the lender lends only part of the purchase price of the property according to the lender's loan-to-value ratio, a lender will verify that a borrower has the cash resources to make the required down payment. If someone is lending an applicant a portion of the down payment with a provision of repayment, a lender will consider this another debt obligation and adjust the debt ratio accordingly. This can lower the amount a lender is willing to lend. All right, so essentially what this is saying is that because this borrower has another payment to his uncle for the down payment of his property, the difference in which the borrower can afford another payment is smaller. Right? Remember what debt to income ratio is. Debt to income ratio is seeing the expenses that the borrower has versus the income they're bringing in. So with that additional payment, the lender will then say to the borrower, well, it doesn't look like you can afford what we originally pre-approved you for. Therefore, we will approve you for a loan, but it'll be for a smaller amount. It'll be for an amount that your budget can afford. Which of the following is a common risk relating to agency relationship? A, failing to inform and disclose properly. B, failing to take personal interest in a transaction. C, acting as an exclusive agent without an oral agreement. D, forgetting to record the listing agreement. And the answer is A as in apple, failing to inform and disclose properly. Agency risks commonly concern the requirements to inform and disclose. Most states require agency relationships to be in writing and to be disclosed to all parties to a transaction. In states that do not use agency, there is still an obligation to explain and disclose the nature of the relationship. And that's it, folks. 25 questions, done and dusted, right? So if you found value in this video and you want more like this, go ahead and click this link right here. And if you want to further prepare with U.S. Realty Training, go ahead and click on that link in the description box or in the comment area, and we'll get you all set up. But until then, I shall see you the next time.